Hi and welcome to our little webinar. Nigel Evans from Aptum Legal. I'm joined here by the fabulous Marianne Marchesi from Legalite. Hi, Marianne.
Hello, thanks for having me.
Oh, no, thank you. And thanks for joining us, everybody. We appreciate your time. We're going to talk about franchising disputes today and really just a kind of practical overview to give a kind of a toolkit to help both franchisors and franchisees navigating their way through disputes. We're going to cover a few things. We're going to talk very briefly about the new franchising code. We're going to keep that brief. We're going to talk about ways to minimise dispute risk. We're going to talk a little bit about the common dispute triggers and perhaps ways to diffuse those early. We'll talk a little bit about strategies for dispute resolution. And if we have time, we'll talk a little bit about trends in franchising. So Marianne, let's get started. I want to talk about the new franchising code. This is not a webinar about the franchising code. There's plenty of information that's been done to death. But tell me, how is it playing out? What effect is the new franchising code having?
Interestingly, I say this after having been through quite a few franchising code changes over the last 15 years, essentially. This round of changes was a lot of red tape, like a lot of just technicalities that were added into the code. And for a lot of franchisors who were already operating at best practice, those changes might not have had much practical impact. Mm-hmm. But some of the key changes that kind of did raise some red flags in the franchising industry were ones around allowing franchisees a reasonable opportunity to make a return on investment. So, as I said, if franchisors were already operating at best practice, that opportunity should be built in to their franchise model. But yeah, it certainly did spark some concern about, making guarantees around ROI.
Yeah, I found that change particularly interesting because, the code is intended to provide some clarity both for franchisors and franchisees, and that clarity's supposed to have the intention of being able to avoid disputes and indeed make that dispute process easier. But when I looked at the ROI provision, it struck me that it could actually increase the number of disputes. It seemed to be addressing what is a genuine concern in the industry, in franchising, but in a way that almost implicitly does the opposite of what it's intending, which seems to implicitly suggest that the franchisor is giving some guarantee about return.
Yeah. And I must say, when I read it, the first draft of that clause, my team and I had a bit of a panic, like, oh my gosh, this changes everything to have to guarantee, as we thought, a return on investment. The technical wording of it, though, is that the franchise agreement must provide for a reasonable opportunity. So that could come down to things like making sure that the length of the franchise agreement is kind of balanced against the capital investment that a franchisee has made in the business. But certainly you're so right. It's something that calling it out in black and white can actually cause a lot more confusion and disagreement down the track. The changes only came into place on the 1st of April, so we're yet to see how it's played out. But certainly we're so conscious of it in our drafting now.
Yeah, and look, the economics of this underpins so much about disputes in franchising. We'll get to talking about some of these triggers, but clearly the primary trigger tends to be around the performance of the particular franchise and the experiences of the franchisee not working out as they expected. It strikes me that things like return on investment would just be seen as good practice by a franchisor in any event. What sorts of discussions are you having with franchisor clients about how to address this ROI provision?
I think that's a really great point. That franchisors want their franchisees to succeed as well. No franchisor is entering into a franchise agreement and hoping the franchise fails. When the franchisee wins, so does the franchisor. So, yes, as I say, it kind of already has been built in. But the things that we're advising on are making sure that the term of the franchise agreement, which is usually 5 years in most cases, is balanced against the investment that the franchisee is making. If there is some sort of significant capital investment that they need to make later on in the term, looking at perhaps extending the term to allow them to make a return on that investment. Or if you're entering into short-term franchise agreements for some reason, and that happens where, for example, the franchisee might not be able to get the lease term aligned, maybe pro-ratering the investment or making a contribution from the franchisor. So there's other strategies that we would be looking at with our clients to make sure that they're not falling afoul of that provision.
Yeah, and this is all falling into the category of how we might go about minimising risk. And so much of that seems to be about making sure there is, a robust process around the disclosures, and particularly the financial disclosures of franchisors, and indeed a robust process for franchisees around the assessment of that financial information. Given that this is such an area that triggers so many disputes, what do you think are some of the things that can be done at an early stage to avoid that kind of conflict that might arise over these issues?
Yeah, so it's a huge area that, if not dealt with properly at that early stage, can lead to disputes down the track. So this provision in the code is probably not going to do much to protect anyone. But more importantly is that process that franchisors and franchisees follow early on. So for franchisors, that could be, actually sitting down with the franchisee and going through, the cost involved in setting up a franchise, encouraging them to speak to other franchisees, but really, really importantly, the franchisee needs to get independent financial advice. And that's not a mandatory requirement under the code, but certainly it's something that a lot of franchisors can consider making mandatory as a policy, because to be able to, encourage franchisees and to be able to show that the franchisee obtained independent financial advice and went through that process themselves does help ward off disputes later.
And so much of this early stage part when the franchisor and franchisees are thinking about entering the franchise agreement, again, it just seems to come back to the fact that there's an alignment of interests. So there's an interest for both parties to make sure they're setting each other up for success. And so much of that relates to ensuring that there's a free flow of accurate information and an appropriate information exchange. Where are people getting it wrong then with franchise agreements in particular?
Probably a couple of areas. One area is where franchisors make projections about the earnings potential for a franchise, and they do that for legitimate reasons. Like franchisors also want to sell franchises, so it's often important to disclose some of the potential of the franchise. And then where it can get unstuck is if the franchisee's reality hasn't matched that projection. So we see that a lot. And I guess the other area is coming back to franchisee hasn't obtained independent financial advice, and they really relied on the information that the franchisor has given them and not gone off and verified that independently. Yeah,
on the disclosure information, it strikes me that this must be particularly difficult for new franchisors. Tell me about some of the things that new franchisors can do about this, because in some respects, a seasoned franchisor has a body of data and therefore can rely upon data to make sure their disclosures are in effect more accurate, more robust, more reasonable. But it must be a challenge for new franchisors. What are some of the tips and things that you would suggest for new franchisors?
Yeah, we do see it a lot with new franchisors. They're keen to start building their franchise brand. Usually they've operated one site as a company-owned store, and that's the only metric that they've got to give to franchisees. And the other thing to that is that we often see, rightly so, a lot of eagerness to build really quickly. So new franchisors tend to move through the whole due diligence process, documentation process really, really quickly. which we understand, but also sometimes it's just more important to take a pause, make sure also that the franchisee is the right franchisee for your system, because we, and you may see this as well down the track, we very often see those same franchisees that have signed on in the early stages come 2-3 years down the track, they become disillusioned, they claim that misrepresentations were made, and there's a real mismatch there. And it's also it's very normal for this to happen because franchisees become emotionally invested in the opportunity before they've even seen the documents sometimes, before they've even had advice, if they've even got advice. So, it's kind of pacing that process a little bit better.
Yeah, and I think what this draws out, and it's one of the areas I find interesting about franchise disputes, is that whilst there's an alignment of interests, it's in both parties' interest to ensure success. There's also tension where there is a misalignment or indeed an asymmetry in the kind of interest. The one being that you mentioned, the franchisor has a particular interest in building and growing a network and doing so, often doing so quickly. And that can create some tension around the way in which the disclosure material is in effect a kind of sales process. And then we see those again as we get further down the line in disputes, which we'll touch on, where so much of the interest of the franchisor can be much greater than just what's going on between the parties, interest in the maintaining the network. How do the franchisors get this balance right about providing robust, reasonable disclosure, but doing it in a way that entices franchisees, but not lulling franchisees into thinking they're providing some guarantee on return? What are some of the ways in which they can manage that tension?
Firstly, get really good lawyers.
Well, that goes without saying, doesn't it?
No, but jokes aside, it is really important to get the right people on your team early on. And that might be difficult because, franchisors are budget conscious when they're starting out in franchising. But, even if it's, a sole practitioner or a part-time franchise manager, get the right people that know what they're doing, experienced in franchising, will really help build out those crucial processes in the early stages. However, high touch or low touch you can afford at the start is really important to set that foundation from the start. The worst thing that we see is franchisors that haven't set any processes, haven't perhaps spoken to a franchise consultant before franchising, and are going in blind. And they have very little awareness of their compliance obligations, the financial modelling, and they just want to sell franchises. And that tends to happen because they've potentially run a very successful business and they get asked by maybe clients or employees, have you thought about franchising? And then they go, yep, and then just start franchising. So that foundational work is really critical, and having the right people advising you on that foundational work that are experienced in franchising. And that initial investment will pay off in future. Us lawyers, we're always talking about that. Legal cost is an investment, not a cost. And we truly see that in franchising.
And of course, it's not just legal advice, particularly for franchisees and indeed for franchisors. It's so much now, and particularly with this added emphasis on return investment that appears in the code, so much is about the reasonableness and robustness of the financial modelling and the business model. And certainly the disputes that we at Aptum have been involved in are so much around a misunderstanding about the financial model. And so it occurs to me that it's not just about legal advice, and that I agree with you, that's clearly critical, but understanding and having the right accounting and financial advice to make sure you've got a critical understanding about what the drivers of business success are going to be for this franchise seems really important. Yeah,
for sure. And even we as the legal advisors, we will often turn clients away or turn them back if they haven't done that critical financial modelling first. It's not good enough, especially in today's market and economy, and it's very, very competitive in franchising, to say, oh, my competitor is charging X percent royalties, I'm just going to do the same, or, you know, do a little competitive buffer. Because then what happens down the track is they haven't done the modelling to support that. They don't know what support they're providing for those royalties or those fees. And then again, disputes happen because the franchisee is not getting what they would expect for what they're paying.
Yeah. Why are franchise agreements so long?
Oh, they are so long. It kills me. Even as a franchising lawyer, my dream is to create like a 20-page franchise agreement, but it is near impossible. And I've said this to a client before, and she said, well, do it with us. And I was like, I wouldn't do it with you. It is such a huge risk. I cannot make you a 20-page franchise agreement because it needs to cover off so much, not just as lawyers, obviously, we're always anticipating worst case scenarios. We cover all of those off. And then there's franchising code terms that we need to comply with that have to be in there. So by the time you're done just covering the essentials, it's like 80 pages.
Yeah.
And then when you're at 80 pages, you're like, oh, we'll add in the nice to haves as well. And it gets you to 100.
This is one of the ironies about regulatory protection, isn't it? I mean, so much of the regulation is around ensuring protection for franchisees, but of course, that kind of intervention can add layers of complexity.
Yeah,
it does. And it seems to in this franchising space, and hence the need, despite the regulatory protections, you still need that, still have that need for good advice.
Yeah, absolutely. I mean, it was the case even 10 years ago that franchisors could manage their documentation internally to some extent. But I even advise against that now, whether it's with Legalite or another firm, get a lawyer to be handling your processes, your legal processes, because it is so easy to just slip up accidentally. Yeah. It is highly regulated. So, yeah. So
let's turn our mind to some of the things that, some of the triggers, some of the things that are popping up, perhaps some of the things you're seeing in practice and that I'm seeing in practice. What are some of the primary reasons you see disputes arising?
Coming back to earnings projections, that's a big one that we see. Usually kind of a couple of years into the franchise agreement, franchisees might not be making as much money as they thought they would be making, have realised they've essentially just bought themselves a job, and then they start to think back to, well, I was told, you know, this store over here made $2 million by year 2. I haven't made that. So, claims around misrepresentations and misleading and deceptive conduct. Yes. We see that a lot. Another area that we see is franchisees claiming a lack of support from the franchisor. And again, usually it's a couple of years into the franchise agreement where they feel like the franchisee could run the business the same and not pay fees or run it better in some cases.
This is raising some couple of issues. So let's break these down into a couple of things. So firstly, economic performance and certainly the disputes that we've been involved in with Aptum. When I think about the underlying cause, it's invariably some form of problem with the financial performance of the business and the individual franchise business. And then there's separately these issues about the level of service and support, which ties in with fees, and fees obviously becomes a significant trigger point for disputes, and obviously those two are connected in many ways. Let's start with the economic performance one. It's certainly what I see is the very pattern that you've described, and that is the financial performance of the franchisee starts to wane. They start to have some difficulties, and then they start to go, well, why is this happening? And the first place they would look to is, well, what was I promised? What was I told? And they're either look to that first, or they're looking to that as a reason for to explain their poor performance, which of course puts us into the dispute territory. Now, this highlights the whole thing around disclosure that we've been touching on, but what sort of steps can we do early on when we're seeing problems with franchisee performance to try and avoid some of these things blowing up into a full dispute?
Yeah, a couple of things. Very, very early on, making sure you're selecting the right franchisees for your system as well. Most established and sophisticated franchisors will go through a bit of a process of screening and, qualifying the franchisee's experience, even reference checks. There's profiling tools that you can use. They're all great, and a lot of new franchisors use them too. But new franchisors often, as I said, want to grow their franchise network, so might deprioritize some aspects of how they screen franchisees, and that can lead to, those kind of issues. So, I think franchisee selection really, really important. But then on an ongoing basis, once they are franchisees, really monitoring their performance on a, monthly, weekly basis. And when you start to see some cracks showing, jumping on it straight away, whether that's, coaching them through performance or giving them a little bit of fee relief to get their, feet off the ground, looking at ways that you can support them and being really proactive about that support in the early stages.
Yeah.
Usually when I see franchisees not performing, we see it like 6 months, sometimes 12 months down the track. And for those 6 to 12 months, the signs were there.
Yeah.
And if the franchisor had jumped on it early, it may not have gotten to the stage of dispute.
Yeah, and so there needs to be a sense of it's almost like there's an expectation that the franchisor is going to play some form of coaching and support role for the franchisee. And there is, again, a mismatch here in the business experience of the franchisor versus the business experience of the franchisee. Yes. There's often a mismatch there, and that, I suspect, creates an expectation around that. So I assume part of this is making sure franchises have a developed understanding about the way in which they're going to approach these kind of financial performance problems. And resourcing the support.
Yeah, absolutely.
And are you seeing that as a trend?
Yeah, absolutely. Yeah. And again, established franchisors will usually have franchise performance managers in-house, or if you can't afford that, that is, makes complete sense. There are external companies and coaches that you can lean on for the benefit of your franchisees as well. That's, not too cost prohibitive, and that comes back to your fees. If you can't afford to have a, franchise performance manager, your fees should reflect that as well. But franchising is such an interesting beast because it's one of the, if not the only business where the business owner, being the franchisee, has someone to point the finger to. I mean, aside from government, we all blame government for everything. But, if you have opened up a small business and it's not performing well, you kind of don't really have anyone to go make a claim against or misrepresentation claims or et cetera. So it's very unique in that sense, and that just comes with the nature of franchising, and franchisors need to accept that is the reality. Be really proactive about providing that support. Yeah,
and that goes back to what we were saying about this ROI provision in the new franchising code. It seems paternalistic in a sense, like you can see how it feeds into this idea that the franchisee wants to feel protected in some way by the franchisor and assured of that success, which starts to create a misalignment of expectations, doesn't it?
Totally.
It strikes me like in any commercial relationship, a big part of both avoiding the triggers and when the triggers arise is that clear communication about expectations. And I assume you see this done well and done poorly. What would you have to say about the way in which the franchisor and franchisee should be engaging with each other around creating set expectations on the level of support, for example?
I think it's a really good idea for franchisors to be clear about what their royalty actually includes, like what actual support does it cover. It's not just a clip of the ticket for buying into a brand. It is more than that. So be really specific about this is what you're going to get when you are a franchisee of ours. And also recognising that a lot of franchisees statistically have never owned a business before. They often are, depending on the industry obviously, but sometimes they're they're migrants. Sometimes they used to work in corporate and this is the first time that they have owned a business. A lot of franchisees are recruited because they were previously customers or clients of the franchise brand. So I think recognising, as you said, it's kind of like that child-parent relationship in some ways. And yeah, you're also teaching them as they go through that franchise journey. You're teaching them about being a business owner, and yeah, be really clear about what you're providing as a franchisor. From a franchisee's perspective, leaning on the franchisor. They are paying fees to the franchisor. They are part of a brand, and also accepting that because they're part of a brand, things need to be done a certain way. They can't necessarily act outside of the bounds of the franchise because, yeah, if they could, go out on your own. So it's just understanding the realities of what a franchise relationship is and leaning into that.
Yeah, so you mentioned that pricing and fees becomes a trigger for disputes, and we talked about its relationship with economic performance, but putting that to one side, what are some of the problems or issues you're seeing with the way franchisors are setting their fees?
Setting their fees like payable from the franchisee to the franchisor. Yeah, they haven't done the modelling. Yeah. So like I said, we're seeing some, we obviously, when clients come to us, like I said, we're encouraging them to go to a franchise consultant, but sometimes we do see on the other side franchisors that have not done that financial modelling. So they also can't justify their fees. And the franchisee might be a really, really great operator and they're actually making a lot of money, and they are paying what they feel is like an unfair clip of the ticket to the franchisor, and they're not getting anything in return for it. So, yeah, it does come back to that financial modelling and being able to justify your fees and stand by your fees. Yeah,
and this leads to the problem you're alluding to before, where, and we've certainly seen this from the disputes we've been involved with, where there's that, it creeps in that sense of the franchisee saying, well, I can run this business effectively because it's either I'm not getting the support I expected from the franchisor, or I can just do this better now. And we've seen that. You and I have worked together on things like that. And so one of the triggers around disputes is this issue about, well, I'm not getting what I thought I was buying into. And of course, what people thought they expected or were buying into changes and morphs over time as well. Is this a trend that you see? And if so, what do we do with the franchisee who says, well, I don't need you anymore?
Yeah, it is a trend. And I have always seen it irrespective of how the code has changed over, 15 years. It's very, very common for franchisees to get a couple of years in and go, I should have just done this myself and not paid anything to the franchisor. On the flip side, we don't hear it as much with franchisors who have done that work and are consistently innovating, growing, providing more improvements to their franchise network. And they are the ones that you just hear about, and they're growing really rapidly. And it's because they're investing back into the network. So even if the fees were meant to just cover, say, for example, immediate franchise performance support, they are also using whatever's surplus is left to invest back into the network and improve the systems for their franchise network. I don't know if that answered your question or if I went on a bit of a tangent.
No, and I guess it really just comes down to the strength of the value proposition by the franchisor, doesn't it?
Yeah, exactly. Yeah. And I was going to say, sometimes representations aren't always just financial representations either. Often they are representations about like what they're going to get from the franchisor, or it could be maybe projections about the growth of the franchise that were made at the early stages. Like the franchisor said we were going to have 500 franchises by the end of 2026, and they've got like 2.
And that raises something that we've certainly seen a lot of, and that is I'm going back to now, we're stepping back to the formation of the agreement and the representations and the things that are promised. I mean, one of the things that I've seen that alarms me is the lack of discipline and rigour about what is being said, so what representations are being made, and it strikes me that it's a great discipline for both the franchisor and the franchisee as they're entering an agreement to make sure they're clearly understanding and documenting what the representations are. So many of the disputes we see are where the representations are vague, or someone is saying, I was promised this, and there's a dispute about whether it was indeed promised or not, that where figures are provided but a certain gloss is put around what those figures are, and that's the part that actually forms the representation. And so it does strike me that one of the ways in which you can prevent these things from, these disputes from flaring up is to a bit more rigour in the way we go about documenting the information exchange and the representations are made. Is that something you're seeing good franchisors do and diligent franchisees?
Yeah, and we're also seeing, when it does reach dispute stage, the ones that have documented everything have a better chance, and you would see that more than I would.
Yeah.
But yeah, document literally everything, because a lot of those conversations in the early stages are verbal conversations. So whether you're a franchisor or franchisee, send an email after the conversation to confirm this is what we spoke about. Make sure there wasn't any confusion or, misunderstanding. Sometimes the franchisee might have understood something as one way when actually the franchisor meant something else. So that's really important. Have the verbal conversations, but follow it with an email.
Yeah.
And then once it reaches the legal documentation process, we usually get we call it a prior representations deed from franchisees, which is an opportunity for them to outline in writing any representations that were made to them.
Yeah, correct.
And if they do flag any, we cover it off then and there with the franchisee and the franchisor, obviously, so that there's no disagreement about what was said.
Yeah, that's a terrific tip, because it's so much of it's just about making sure there's clarity around what's being said and the information that's being exchanged, and clarity in a way that's preserved, so
Absolutely.
that you've got something to fall back to when there is that dispute about what's said and what the expectations were. And
that can be the really useful thing of having lawyers involved, because we're trained to see red flags like that. Like I had an example recently where we're acting for the franchisor, and the franchisor and franchisee's lawyer on the other side were negotiating around some terms, and our client agreed to a particular term, and the franchisee's lawyer said, okay, thank you, we're taking this as an inducement to enter into the franchise agreement. And we said, no, this is not an inducement. This is a commercial negotiation. The franchisee is obtaining legal advice, so we're agreeing to this, but it should not be taken as an inducement to enter into. That's like a huge red flag that if you weren't represented by a lawyer, you might just go, what does that mean? Yeah, sure, okay.
Yeah. And it's interesting because you that's a red flag in the sense of the nature of the commercial relationship as well, isn't it? I mean, you want to be setting up a relationship where both parties are working cooperatively, and therefore that kind of transparency is seen to be in the interest of both parties rather than a sort of gaming one-upmanship.
Oh, yeah, no one's twisting anybody's arm to enter into, which is essentially what an inducement is. Just clarifying representations at an early stage. Yeah,
one of the things I find interesting about franchising is the stuff around compliance and complying with the franchisor's legitimate interests, and that is, you talked about some of this before about making sure that a franchisee is aware of the fact that there's certain guardrails they need to be operating in. It strikes me that presents a business challenge for franchisors and franchisees. But from your perspective, how do franchisors manage this in a way that doesn't feel like they're taking control or micromanaging a franchisee's business? This must be a really difficult balance to strike.
Yeah, it is a really difficult balance to strike. I think the way that we often see that being managed is you might have either new franchisees or your lower performing franchisees do get more attention. That's a tricky place to fall into, because then your good franchisees might feel neglected. So it is about striking that balance. It's very similar to having employees. Like if you're putting all your attention on, the employee that needs so much mentoring and learning and development. I'm not speaking about my team here, by the way, just in general. It does take away from like your A-grade performers and then they start to feel neglected and then that has flow-on effects down the track. Very, very similar in franchising. You don't want to put too much focus or micromanage any of your franchisees, but certainly, lean in when franchisees do need more support. So it's such a tricky balance to get right, and franchisors will probably get it wrong, and I think they need to be okay with that. Yeah. They're not always going to get it right. You are always going to be learning as a franchisor and getting better as your job as a franchisor, which is such a different job to just being a business owner. Just, give yourself that grace and patience to get better at it as time goes on.
That idea of underperforming franchisees is interesting, and it highlights to me what I alluded to earlier, and that is that the different interests that a franchisor and a franchisee have in a particular dispute. In most commercial disputes, the issues in dispute tend to be confined but as the issues between the parties that are necessary to resolve that dispute. But one of the interesting things I find about franchising disputes is the franchisor's interests in particular are so much broader than the immediacy of that particular dispute. And underperforming franchisees is a good example. There is the idea about having to protect the network, the idea about protecting the value proposition for other franchisees. And I think having an understanding that a franchisor is coming from a slightly different place than a franchisee is an important way to start thinking about how to resolve a dispute and what you should do to approach a dispute. Tell me how that plays out for you. What are some of the broader implications that you see franchises worrying about when a dispute arises?
Yeah, that is so true in franchising. And I think if franchisees had more of an awareness that the franchisor is not just thinking about this immediate dispute, they are, but they're also thinking about the broader network, that would help a lot of disputes to resolve earlier. But a really critical thing for franchisors when they're in a dispute is the precedent that this would set for the rest of the network. So you might be a franchisor who's in a dispute with a franchisee and you just want to get them out of the network, and you know what, you're like, just get out, don't pay anything, just leave. But what precedent does that set if word gets out? Oh, you can just get off scot-free. They won't come after you for anything for breaking the franchise agreement early. So as much as franchisors sometimes do want to take that route, they don't because of the precedent it sets. And yeah, as you said, thinking about the broader implications on the network with like culture and having a network of really engaged franchisees, that can be really difficult to maintain when you're in a singular dispute with a franchisee. Yeah,
and I think what it seems to emphasise to me from a dispute perspective, I mean, the first question we always ask a client is, what are your broader objectives here in a dispute? And it strikes me that a franchisor needs to have a very clear idea about what are the underlying objectives and principles that govern the way in which they engage in a dispute with a franchisee, because that dispute is obviously going to have broader implications for franchisees, but it also says something about the way in which a franchisor deals with its franchise partner. And so it strikes me that one of the critical things for a franchisor is to not jump from one dispute to the next without some idea about what their broader objectives are each time a dispute arises, and indeed some underlying principles about how they might go about
how
this.
How we approach it, yeah.
This is how we do it.
And I love that you asked that question from the outset, because a lot of litigators don't. And that strategy, that outcome, working from an outcome-first approach is so important in franchising.
Yeah, it seems particularly important when you're flagging so much to other people when you're involved in this dispute, and certainly in our experience, the these disputes aren't contained. Like franchisees talk to other franchisees in the network.
They all talk.
So the way in which a franchisor is dealing with this, it puts so much more pressure on the franchisor to have a clear understanding about what they're trying to achieve and the kind of principles they apply, because you need the transparency and the certainty and the consistency around their approach becomes really important, because they're going to be subject to franchisee chatter and gossip and disquiet.
Absolutely. And if it makes it all the way to court proceedings, that's, usually on the public record, but also it will typically have to be disclosed in the disclosure document as well in future. And unless, a franchisee that has exited has asked for their details not to be disclosed, their details will be in the disclosure document for future franchisees as well. So, it's that long-term impact of, the dispute that they have to balance as well.
Yeah, and that's tough for franchisors, because we've seen that play out where the disclosure obligations around court disputes becomes a real leverage for franchisees, because there is that sense that that I can apply that pressure, knowing the franchisor feels concern and trepidation about the court proceeding because it's going to be disclosed. So again, it strikes me that the franchisor must have some sort of framework for making these decisions, because if you run from the court dispute, you find yourself compromising on a range of things that might have flow-on implications for other franchisees, or indeed for the protection of the network. But equally, if you're heavy-handed, you might find yourself in circumstances where franchisees think you're litigious.
Absolutely. And there are some franchisors who have a reputation for being litigious. That works really well to maintain strict compliance in the network.
Of course.
In terms of reputation and perhaps signing on new franchisees, not so much. But I think it is important to go all the way, so to speak, if it's a dispute that is really important to your network, to your brand, to the integrity of your brand, that you do see it through and not be scared about having to invest some, legal costs into something that might have a long-term beneficial impact. And as you said, it's like, what are your objectives? And that's a very quick key question to help franchisors determine that.
Yeah, and I can see how the dispute resolution process for franchisors becomes a big part of their investment in the maintenance of their business model.
Yeah, exactly.
It's in effect almost like a core function of sustaining the effectiveness of their business model. They need to be able to manage these disputes in a way that balances all of those interests. Yes. You're at a position where you're seeing disputes rise, and you certainly see them before I do. I tend to see them when it's all falling apart and we're trying to patch things up. What are some of the early steps you think people can take when it's pretty obvious we're moving into dispute territory?
Yeah. Like any relationship, it is about communication. To have those conversations with either the franchisor or the franchisee really early on when you feel like something's off, and work together to come to a commercial resolution. I mean, as commercial lawyers, we're not typically recommending a strict legal path. We're actually looking at ways to avoid the legal path. So if it's come to you, we've probably exhausted all of those options first. And that is really, making some compromises, negotiating in good faith about what can we do to fix this together, and working collaboratively together, and actually just set aside the legal argument and the franchise agreement for the moment and see if you can resolve it commercially first. I think that's really important. I think from a franchisor perspective as well, is getting on compliance early. And again, that doesn't need to be a strictly legal process. It can be just, a matter of franchisees paid their fees late. Get on it now, not 6 months later when it's racked up to $60,000 and then you've got no hope of recovering it.
Yeah.
So, as soon as they're in arrears, getting on it, figuring out what's happening, why aren't they paying their bills, before it escalates and gets, harder not just to manage but harder to recover.
Yeah. So much of this, again, just comes down to the sound, sensible business practices.
Yeah.
And so having those clear expectations with your franchisees and some consistency around that, like default in payment of fees, for example, that strikes me as an area that can have a really big impact the moment it spreads. You're letting one franchisee and giving them an awful lot of leeway, and what I've seen in the past is where the franchisor might effectively treat someone differently because they have a different kind of relationship with that particular franchisee. And again, so much of it seems to me about having a very consistent and principled approach to these things that are, but not so much that you obviously completely ignore the possibility for some discretion and some compromise.
Course. Yeah, absolutely. And if there is a compromise, document it again.
Yeah.
So, but usually when we see, say, franchisees haven't paid their fees for some months, they've got other issues in the business as well. Like they may not be paying rent on time or their insurance premiums. Like there are other issues at play as well. It's very, very rare that they would just only not be paying their franchise fees.
Yeah.
And that to me is a franchisee who's in financial strife. So that's a whole other, that needs to be dealt with a whole other way and managed. And it might be that they need to exit. And you can manage that exit in a way that is also commercial, and it doesn't need to be a legal, strictly breach termination path.
That becomes the canary in the coal mine, doesn't it? It's the moment you start seeing those defaults, it's an indicator that there's some problem with financial performance. And if you're not dealing with that in some way, it's going to escalate. It's going to get worse.
It always does.
It always does. Let's turn our mind to some of the trends that are going on in franchising. What are you seeing?
Interestingly, I'm seeing some franchises move away from franchising, actually defranchising. Some are, in the news, it's public knowledge. Others are working through that process slowly over, they've usually got like a 5-year plan to do it. Caltex, for example, used to be franchised. They completely exited franchising, I think, about 3 years ago, and there's a process that, you have to do that. And I think a lot of that comes from franchising. It was like the golden years 10 years ago. It was, if you were the franchisor, you were genuinely in a position of power. It was a very unlevel playing field. The changes to the code over the last 10 years have tried to improve that. But it's kind of gotten to the point where it has improved areas of it. However, it's also become very, very complex to manage. There's a lot of red tape. If you're a franchisor, your legal spend's probably going to be quite steep compared to maybe a corporate business that's of the same size but isn't franchised. And that is just because of the compliance. So, we are kind of seeing a move away from franchising, interestingly. Obviously not for franchisors who are very much, right in the thick of franchising and they are continuing down that trajectory, but they are aware of the reality that's associated with that, and so they're invested in it.
And do you think that compliance is one of the big drivers for this trend? Is it just the sheer burden for franchisors? And that's making it harder to have an economically viable business model?
I think, yes, for some franchisors who weren't set up for that level of compliance currently. For new franchisors who are doing the foundational work now, they'll be okay. But for a lot of kind of the legacy franchisors who just were not set up for this level of red tape, that's where we kind of see the step away from franchising. That foundational work is really important, to have the systems in place, the right people on your team, the right financial modelling. All of that's already done. That makes compliance so much easier and also cheaper. Yeah. And we add that to the really great tip you indicated earlier in our discussion about getting the screening right. Yeah.
And that seems to be so vital to making sure the business model is effective. Get the screening right and then have the robust processes and systems in place.
Yes.
which means there's still clearly plenty of opportunity for franchisors and indeed franchisees.
Yeah, and it's not all is not lost if you don't already have that in the system. It just means you need to recommit to doing it at some point. If you are going to stay in franchising, then committing to, you know what, let's just look at everything all like with fresh eyes, with fresh people, put some new processes in place and foundations in place. Obviously, AI is huge now. Like, how is that impacting our business? Do we need to be looking at our AI policies and processes as well? And how is that going to fit into the offering that we give to our franchisees? There's so many things that franchisors have to balance now. You know, the cost of living, the cost of doing business, AI, and then franchising code compliance.
Yeah. I think what's interesting about franchising disputes and particularly when we get to this part about early resolution, I mean, we have baked into the code some dispute resolution procedures and some early resolution. So there is the kind of structure for people to follow to engage early. And as a disputes practitioner, well, that's terrific. I am surprised by, for example, there doesn't appear to be a huge uptake in things like arbitration in franchise agreements. That strikes me as odd, given the economics of franchise disputes are difficult in a court setting. So there is, it really is quite hard to have, because of the nature of the franchising business and the economics of the dispute, it's very difficult to do it in a way that's reasonable and proportionate. I'm straying here into things like arbitration, but it does surprise me that there's not more emphasis on some of those things to avoid what can be a pretty costly and time-consuming and uncertain court process. And I'm wondering perhaps that might, in terms of a trend, we might see a greater willingness to have more communication, more reliance on alternative dispute processes, more reliance on genuine preparation before mediation and negotiation and commercial discussion as a way of trying to avoid these disputes.
That's really interesting to me because also, as not being a disputes lawyer, I don't see much of arbitration. And typically, so the introduction of arbitration as an alternative dispute resolution method into the code was only, I think, 5 years ago. The changes 5 years ago. And prior to that, it was just the done thing that you would do mediation and then if it's not resolved, court disputes. So I think the franchising sector doesn't really understand or know about arbitration. I certainly don't. So it's interesting to the point around that awareness, I think, and education that arbitration is a viable model. The franchising sector doesn't really know that.
I think it's just an enormous opportunity to reduce the cost of disputes. As someone who practices primarily in the courts, but I practice with arbitrations as well, the real benefits of arbitration are the speed and the ability to control the process in a way that creates far greater efficiency. So, and therefore create so much more certainty for the people in a dispute. And as I say, because of the economics of franchising, it strikes me that it's an obvious area, and certainly one that I think will only gain traction if franchisors are putting in arbitration clauses into their franchise agreements. It is possible for parties to agree separately to have a dispute go to arbitration, but where people don't really understand or know about arbitration, getting agreement is difficult. So I think for there to be something that in effect reduces the cost of disputes, increases the level of certainty, makes it an easier process to iron out those ones where you can't negotiate with. I think arbitration's a wonderful thing for people to be thinking about.
Yeah, and it should be in most franchise agreements now because with those changes, you do have to have ADR clauses in the franchise agreement, and that includes arbitration. So I think when those changes were introduced, there was not much guidance from government at the time about why are we introducing this? What's the rationale here? Is arbitration actually more affordable? So the franchising sector doesn't really know. And I think that's a huge opportunity to improve dispute resolution rates.
Well, that might be one for the next webinar. We've had a question here about defranchising and how franchisors work through the defranchising process. And the question here is on defranchising, how will you help clients ensure that they are actually, so clients, franchisor clients, are actually defranchising and not defranchising in name only, in that they may run into trouble where it's deemed to be a franchise? We've only got a minute or two. Do you want to talk to that question?
Yeah, sure. So there is a very strict definition of a franchise under the code. If it meets certain elements, like, to keep it short, if it quacks like a duck and walks like a duck, it is a duck. So you can't get around that side of it. To defranchise, the process really would need to be removing some of the elements of what's deemed to be a franchise. And then it's a process. You would allow your franchisees to see out their current terms and then go through a process of buying them back. There were also some recent changes to the code that come into effect in November, that if a franchisor is exiting franchising or exiting the market, they have to compensate franchisees for goodwill as well. So where previously they were just perhaps letting franchise agreements expire and buying back equipment, now there's also a goodwill component. So that's really important for franchisors to be aware of. And if they do want to defranchise, do it before November. But yeah, it's a process.
Okay, terrific. We've run out of time.
Okay. That went so quick. I don't know if the audience felt the same.
It's been a great chat. Thank you,
too.
Marianne.
Thank you.
So Marianne Marchesi from Legalite and Nigel Evans from Aptum Legal. We're grateful for your time. Thanks for joining us. And thanks, Marianne.
Thanks,
it was a great
Nigel.
Chat. Thank you.
Great to chat to you.